the consultative referendum on 3rd of December. Venezuela shall not accept this. Madam President, members of the court, following the attempt to dispossess our nation of its territory by the fraud perpetrated by the Paris Tribunal in 1899, Venezuela adopted, on the basis of its historical position, a doctrine of not submitting the settlement of disputes relating to its vital interests, including independence and territorial integrity, to the decision of third parties. It is a doctrine that does not solely apply to this honorable court. It aims to safeguard the nation's most sacred interests in all international fora and mechanisms. Within the UN, Venezuela has opposed the compulsory and automatic jurisdiction of the court on 12 occasions since its creation, thus demonstrating its consistency in this respect. For this reason, Venezuela is one of the 119 countries that have not made the declaration provided for in Article 36(2) of the Court's statute, along with the countries such as the United States of America and the Cooperative Republic of Guyana itself. Venezuela's historic position is expressly set forth in the 1966 Geneva Agreement, which does not recognize the judicial route as an amicable means of reaching a practical and mutually satisfactory solution for the parties. Venezuela firmly rejects yesterday's statements, which, through crude and childish manipulation, seek to stigmatize the historical tradition and legal doctrine, which in no way represents an exceptional situation and which is shared by the majority of the international community. Without prejudice to our position and doctrine on jurisdiction, we come before this court to defend independence, sovereignty, and self-determination as the inalienable rights of our nation. We are here because Guyana has not only decided to abandon and transgress the Geneva Agreement, but now intends to flout the international order and promote a change in the Venezuelan political system through an interventionist and audacious action that seeks to instrumentalize the court against Venezuela. The line of action is clearly that of judicial colonialism. Consequently, on the basis of the UN Charter and the statute of this court, Venezuela reaffirms its categorical rejection of Guyana's audacious action to interfere in its internal affairs. Nothing will prevent the referendum scheduled for the 3rd of December from being held. Madam President, today we are going to demonstrate that Guyana's request is unprecedented. It is unprecedented and unusual and creates dangers for the rest of the international community, in particular for those states that have constitutional formula for participating similar to those of Venezuela. Guyana unilaterally came before this court in 2018 in open violation of the Geneva Agreement with an outdated claim to try to validate a fraudulent arbitral award that purports to strip Venezuela of 15% of its territory. Today, Guyana dares to distract this court once again in an attempt to prevent Venezuelans from exercising their sacred right to vote on an issue that is specific to them, internal, and of considerable importance, such as the dispute over the 𝘴𝘰𝘯𝘺. They will not succeed. The holding of a consultative referendum is an exercise of the sovereignty and self-determination of the people. Nothing authorizes Guyana to restrict the right of the Venezuelan people to freely establish their political status or to intervene in their internal affairs. Guyana should be reminded that under Article 2 of the UN Charter, and I'm quoting here, nothing in the present charter authorizes the United Nations to intervene in matters which are essentially within the domestic jurisdiction of any state, or obliges the members to submit such matters to the procedures for settlement set forth in the present charter. Similarly, according to Resolution 2131 of the United Nations General Assembly, no state has the right to intervene directly or indirectly and for any reason whatsoever in the internal or external affairs of another state. Not only armed intervention, but also other forms of interference or threats against the personality of the state or against its political, economic, and cultural components are therefore condemned. Every state must respect the right of peoples and nations to self-determination and independence, which must be exercised without hindrance or external pressure and with full respect for human rights and fundamental freedoms. Furthermore, participation in public affairs through referendums is a human right for every Venezuelan. This right is recognized and protected by both our Constitution and by the International Covenant on Civil and Political Rights. There can be no justification for interfering in Venezuela's internal affairs and preventing the Venezuelan people as a whole and as individuals from being consulted. It is outrageous to attempt to replace the popular will of a country with unheard of provisional measures. This would be a case in the history, a unique case in the history of this court and of the world. Madam President, respected members of the court, we have taken due note of the questions raised by this court on the referendum process called by the Venezuelan Parliament for the 3rd of December. We would like to make 4 clarifications in this respect. Firstly, Venezuela has always respected the Geneva Agreement and international law. This position is reflected in every question in the referendum. This is what differentiates us from Guyana's illegal and aberrant behavior. Secondly, Venezuela has a solid institutional system that guarantees the constitutionality and legality of the actions of public authorities. The system has been triggered, and a ruling by the Supreme Court of Justice has confirmed the constitutionality of the referendum questions. In Venezuela, nothing is above the Constitution. Thirdly, the referendum is a single and indivisible process in its entirety. It represents the diverse visions and aspirations of a society. Venezuelans have the right to consult and listen to each other. No one can deny or divide this right. Finally, the state of Venezuela will not turn its back on what the people decide during the referendum. Madam President, members of the court, yesterday we all witnessed one of the worst ruses Guyana has devised in its false desire to present itself as a defenseless sheep and to portray Venezuela as an aggressor state, that is hindering its development and threatening regional stability and peace. Nothing could be further from the truth. Venezuela has launched a number of initiatives to support the development of the Caribbean people. In 2005, Venezuela created a program to supply energy on financial terms far more advantageous than those offered in the international market in order to stimulate development in the region. Guyana has benefited directly from this program, and its positive impact was recognized in its 2015 report to the WTO, World Trade Organization. For instance, Venezuela has come to supply 50% of Guyana's daily energy consumption. Moreover, it has set up compensation mechanisms by accepting Guyanese rice as payment for Venezuelan oil. Thanks to this program, Guyana's economy boomed long before ExxonMobil's so-called world-famous oil discovery, which incidentally had no impact on Guyana's human development indices. The highest level of socio-economic development since independence was achieved by Guyana thanks to Petrocaribe. In exchange, Guyana has repeatedly flouted the Geneva Agreement and international law.
Since 2015, after the 𝘱𝘓𝘃𝑚𝑜𝑏𝑙 worldwide recognized discovery in the territory in dispute, Guyana has reneged on the Geneva Agreement and joined in the international aggression against Venezuela. It's in that same year that the United States declared that Venezuela was an unusual and extraordinary threat for their national security and put in place a criminal embargo against our economy. Guyana enthusiastically joined this multifaceted aggression plan against Venezuela. Firstly, from its seat on the Permanent Council of the Organization of American States, it supported 15 of the 23 actions that were orchestrated against the sovereignty and the institutions of Venezuela, including the calls made by its Secretary General, Luis Almagro, for the use of military force and the calls aimed at denying the legitimacy of the President of the Republic and the state. Guyana then participated in a group of states that was created exclusively to intervene and attack Venezuela. Within this infamous Lima group, Guyana approved 16 interventionist declarations against Venezuela. Thirdly, Guyana has put its institutions and its territory in the service of the major powers that have always aspired to destroy Venezuela in order to grab some of the largest world reserves of oil, gold, and gas. The growing presence of the United States Southern Command and the frequent joint military exercises with the government of Guyana, along with hostile declarations aimed at threatening Venezuela, are public knowledge. I showed you a video. That was the president of Guyana speaking along with his military forces, saying that he wasn't going to give an inch of its territory to Venezuela. When this, of course, is the territory in dispute. Yesterday, we were astounded to hear Guyana and Guyana's council's lies when they accused Venezuela of threatening peace and stability in the region. The fact is that Guyana, for several decades, repeated this baseless accusation, distorting the very facts in an attempt to shore up its position as victim. For example, in 2015, President Granger filed a complaint with the Secretary General of the United Nations concerning the alleged presence of a Venezuelan warship off the shores of the capital of his country. The evidence revealed that the photograph that had been shown was actually a photograph of a ship arriving in a shipyard in the Canary Islands for repair, and that it was not taken in Guyana. This was done in the presence of the Secretary General of the United Nations. Furthermore, Guyana has prepared for a military attack against Venezuela with the support of its strategic and geopolitical ally, the United States. You can see on the screen the content and the photography. This was the meeting between Secretary of State Mike Pompeo and the President. They signed an agreement for the security in the region that threatens Venezuela. One cannot ignore the fact that the President of the United States at the time and Guyana's ally, Donald Trump, openly declared that all options were on the table regarding Venezuela. And as was confirmed by some of his former advisors, these options included military intervention. In 2022, the U.S. Department of State, that is to say, just last year, the U.S. Department of State published its Integrated National Security Strategy for Training and Resupply, facing the alleged external threat that Venezuela represents for Guyana, whereas what is really at stake is defending the interests of multinational oil companies. In the same vein, The fact that U.S. troops come to Guyana frequently in order to strengthen preparedness through tactical and operational integration, as you can see on the images that you're seeing on the screen. In this chain of events, it is clear that Rex Tillerson, the former CEO of ExxonMobil, was appointed by Donald Trump to the position of Secretary of State in 2017-2018, a period during which Guyana decided to relinquish the Geneva Agreement. It was at that time that the United States supported for the first time Guyana's position in the territorial dispute. Guyana is now directing its action against the Venezuelan population living on its territory, in open violation of its international obligations in terms of human rights and promoting unacceptable xenophobia. Madam President, ladies and gentlemen, members of the Court, Guyana has decided to pull out of the Geneva Agreement and to call upon the International Court of Justice. There were two decisive factors in this radical about-face. Firstly, there is the sponsoring and the financing by the oil multinational ExxonMobil of unilateral action by Guyana before this court to obtain the validation of the fallacious 1899 Arbitral Award. Secondly, the actions taken by Secretaries General of the United Nations that set aside the practice of over 60 years under the Geneva Agreement, where mutual consent was required and binding on the parties in order to designate mechanisms for dispute resolution, is what had always prevailed. More recently, Guyana decided to exceed all rational limits and to flout international legality. Motivated by greed and encouraged by hegemonic powers, it granted oil and gas concessions in a maritime territory that had yet to be delimited. Guyana is aware that it is acting against international law because it has expressly recognized that the delimitation of maritime boundaries was still pending. In fact, the joint declaration made by the Ministers of Foreign Affairs of Venezuela and Guyana on September 30th, 2011, says as follows, and I'm quoting, "The ministers recognize that the delimitation of maritime boundaries between the two states remains outstanding, and they agree that this delimitation will require negotiations." All of this aberrant and illegal behavior have shown the true face of Guyana, an aggressor state, a predator of natural resources, and a violator of international law. In no way a victim. Madam President, in its recent political history, the people of Venezuela have understood that participation is the foundation of a solid and vigorous democracy that combines representativeness and the central role of the people. The question of Guyana Essequibo was and continues to be a question of utmost national importance. This consultative referendum, which must be organized and held, is the expression of our democratic model. Venezuela will not accept Guyana's attack against its constitution and is asking this court to reject this farce and this abuse of procedure that not only distract the attention of the court from relevant and important matters, but also endeavor to abrogate our Magna Carta. The unprecedented request of Guyana will be an occasion for the court to put an end to attempts to institute judicial colonialism under the impetus of Guyana. The people of Venezuela are impatient to vote in order to be able to tell future generations just how proud they were when they defended Guyana Essequibo and the territorial integrity that they inherited from the founders of our nation. The sacred flame of independence, centimeter by centimeter, is now taking hold all over our country. On December 3rd, 2023, the people of Venezuela, in keeping with its democratic tradition, will go to the ballot box to show the world that our rights on Guyana Essequibo are inalienable and indisputable. I would also like to stress just how proud we were yesterday when we saw in this very hall our own Bolivarian National Armed Forces actively involved in promoting the participation of all citizens in the consultative referendum. Venezuela has never attacked any country, nor crossed borders to invade or annex territories. Venezuela has a victim, like so many other countries, of the legacy left by the British Empire that spoliated the territory from its legitimate owners and gave it to those who never had any right over said territory. I could not end without responding to the most egregious defamatory statements that we heard yesterday against our head of state and our people. President Nicolás Maduro is a true Democrat who consults and listens to the people, and a man of peace who always promotes dialogue and negotiation to settle disputes. He has never become an ally to powers that today are massacring the Palestinian people, that have bombed Libya, Syria, Iraq, and Afghanistan. Never. Venezuela is a people of peace that will never be brought to heel by any other power, and that will never be an accomplice of merciless multinational companies to the detriment of the sovereignty of states. Madam President, the order of Venezuela's presentations will be as follows. Professor 𝘔𝘵𝘵𝘦𝘯𝘵 will address the unprecedented character of Guyana's application and the absence of prima facie jurisdiction to indicate the provisional measures. The agent of the Venezuelan Bolivarian Republic, His Excellency the Ambassador Samuel Moncada, will then read the final submissions of Venezuela. I would like to thank you, Madam President, and kindly ask you to give the floor to Professor 𝘔𝘵𝘵𝘦.
Merci beaucoup.
I thank the Executive Vice President of Venezuela for her statement, and I now invite Professor 𝘔𝘵𝘵𝘦 to take the floor. You have the floor, Professor.
Madam President, members of the court, it is a great honor for me to appear before the court on behalf of the Bolivarian Republic of Venezuela. I will address three issues in my presentation. First, I will highlight some of the main deficiencies of Guyana's request. Then I will demonstrate that the court should reject in its all this unprecedented request, since on the one hand it amounts to an unlawful interference with Venezuela's undisputed domaine réservé, and on the other hand, the court does not have prima facie jurisdiction to rule on Guyana's request. Madam President, I will now address some points which highlight three main deficiencies of Guyana's request. The first deficiency is that none of the claims in the provisional measures request are new either to Guyana or the court. Whether it is the invalidity of the arbitral award of 3 December 1899, question 1, the importance of the Geneva Agreement in order to reach a satisfactory solution to both parties, question 2, or the disagreement as it comes to the jurisdiction of the court in the present proceedings, question 3. These are all matters that have been known by the court and Guyana for a long time. Importantly, the consultative referendum, the main substance of Guyana's request, was announced by Venezuela at a meeting held by the President of the Court with the representatives of the parties on 26 February 2021. Whilst Guyana requested a period of 9 months from the date of the order fixing the time limits for the preparation of its memorial, Venezuela indicated that, I quote, "It has not yet decided on its position in relation to the proceedings, and that in light of the alleged serious implications of the court's judgment of 18 December 2020 for its sovereignty, it was required by its constitution to conduct popular consultations on the matter, which would require a significant amount of time, and that it also faced a number of other difficulties in preparing its pleading." End of quote. Madam President, members of the court, how can it be that the calling of a referendum that was announced to Guyana over 2 years ago now results in a request for provisional measures? Guyana has had ample time to raise these issues, but has decided to keep silent until now. This is not congruent with the essence of a request for provisional measures. As it comes to the referendum's fifth question, it warrants some specific comments. This question deals with the prospective creation of a Guyana Essequiba administrative region and the development of an integral attention plan, which would include the issuance of identification cards and the incorporation of the said state in the territorial map of Venezuela, None of these administrative actions can affect Guyana's alleged title to the disputed territory. Concerning the issuance of IDs, this would benefit the frontier population, particularly those who engage in commercial and day-to-day activities and will ensure the free movement of persons in the area. Lastly, the incorporation of Guyana Essequiba in Venezuela's cartography is something that Venezuela, who has a plausible claim to the disputed territory, has already done since many decades ago, and of which Guyana, yet again, is very much aware. The second deficiency of Guyana's request ultimately results from Guyana's protest against a referendum to be held in Venezuela next month, an internal domestic matter that cannot have any damaging effect on Guyana's alleged title to the disputed territory. This is why you heard nothing or nothing serious on this point in Guyana's pleadings yesterday. All atmospherics, but nothing of substance. This should be enough to dismiss Guyana's request, because the court's case law makes it clear that provisional measures cannot be granted where what the request for provisional measures, I quote, aims at preventing cannot in any event or to any degree affect the existence or value of the sovereign rights claimed over the territory in question. End of quote. Shortly put, it seems that Guyana deeply misinterprets the point of this upcoming democratic exercise, somehow reading in this referendum, amongst others, Venezuela's intention not only to reject the 1899 arbitral award and the jurisdiction of the court, but also intention to resort to unilateral action. Clearly, Guyana's case hinges upon an alleged intention that is entirely hypothetical. Yet, provisional measures have never been, are not, and cannot be based on an applicant accusing the respondent of having some hypothetical intention not to respect the judgment or international law. Violation of international law is in most cases a question of fact, not of intention. This point is well illustrated by the court's practice. In the fisheries jurisdiction case, the United Kingdom requested, and the court granted, provisional measures not on the basis of Iceland's intention to adopt regulations on fishing rights, but because the state had taken concrete steps in that sense. In Costa Rica versus Nicaragua, while Costa Rica had alleged certain intentions on the part of Nicaragua, the court's analysis focused on Nicaragua's explicit announcements that it would carry out certain activities in the disputed territory. In this respect, one cannot help comparing Guyana's request to the famous Cervantes novel Don Quixote, where the main character attacks windmills he believes to be ferocious giants. But none of the contested questions in the referendum is a ferocious giant. The third deficiency of this provisional measures request is that the application lodged by Guyana 5 years ago, had already claimed that Venezuela was about to use force in support of a request that the court rule and declare that Venezuela should not use force or threaten to use force against Guyana. Venezuela made it clear in its 2019 memorandum that it was, I quote, not going to resort to force, not only because it is prohibited by international law, but also because of its own regional policy of peace, integration, and solidarity, end of quote. Back then, the court, and rightly so, paid no attention to Guyana's unfounded allegations. Guyana is now coming back with the same allegation in the form of a request for provisional measures, going even further by asserting that Venezuela intends to reject the court's judgment. However, it cannot be, to quote the nuclear test cases, the court's function to contemplate that a state will not comply with its judgment, and certainly not on the basis of a mere hypothesis as to what a state may have or may not have the intention to do. Madam President, Guyana's request ultimately is based on the unwarranted premise that the court has already ruled on the merits in its favor. From there, Guyana postulates that Venezuela intends to reject the future judgment and ask the court to order Venezuela to accept this future judgment. This is an unprecedented attempt that is not only contrary to the very nature and raison d'etre of provisional measures, but also to the very function of the court under Article 38, paragraph 1, which is to settle disputes. Guyana is asking the court nothing less than to prejudge the merits of the pending dispute before it by explicitly approving Guyana's claim and ordering Venezuela not even to maintain its own claim. This clearly denotes an abuse of process from Guyana's part. Madam President, members of the court, let me now turn to my second argument concerning Guyana's interference with the domaine réservé of Venezuela. As Guyana has indicated, its sole objective is to obtain that the court put an end to a national consultation of the Venezuelan people in accordance with the constitutional organization of Venezuela. But there is an inescapable problem with Guyana's request. The problem is that if there is one area that undoubtedly still falls within the domain réservé of Venezuela, it is this one. Nothing in international law allows Guyana to dictate to Venezuela through the court how its constitutional bodies should perform their functions. Madam President, permit me to recall that it is common practice in constitutional law to hold referendums, especially when the boundaries or extent of the national territory are at stake. Seeking the popular opinion on such issues belongs in principle to the domaine réservé of states. Indeed, Sir Gerald Fitzmaurice described, I quote, the relation between a state or government and its own nationals or populations as the most sacrosanct corner of the reserved domain. This foundational principle is inherent in Article 2, Paragraph 7 of the United Nations Charter, which refers to matters which are essentially within the domestic jurisdiction of any state. Former President of the International Court of Justice, Judge 𝘔𝘁𝘵𝘀, in his commentary of Article 2, Paragraph 7 of the United Nations Charter, pointed out that this provision, I quote, s'impose à l'ensemble des organes des Nations Unies.
Is incumbent on all of the UN organs and is applied to all functions undertaken by these organs.
Court as the UN principal judicial organ. The court knows all this very well, since it itself held in Nicaragua versus United States that, I quote, a state's domestic policy falls within its exclusive jurisdiction, provided, of course, that it does not violate any obligation of international law. And the court added, a state which is free to decide upon the principle and methods of popular consultation within its domestic order is sovereign for the purpose of accepting a limitation of its sovereignty in this field. End of quote. But precisely, Venezuela has never accepted any international law limitation on its sovereign power to decide if, how, and when to consult its population by means of a referendum. The organization of this referendum plainly falls within Venezuela's reserved domain, whereas no international law obligation could impact its holding or content. Guyana invokes no basis for any limitation to this reserved domain. This is because nothing in international law allows Guyana to dictate to Venezuela once again through the court opportunistically instrumentalized how its constitutional bodies should perform their democratic functions. It would be unprecedented for one state to force another to forego a domestic popular consultation, and for the court to indicate to a state not to consult its population on such a crucial matter. In the same vein, the court will recall that it had paid no attention in 2022 to Nicaragua's request in alleged violations of sovereign rights and maritime spaces in the Caribbean Sea, Nicaragua versus Colombia, that Colombia be ordered to ensure that a judgment of the Colombian Constitutional Court does not impede the execution of the court's 2012 judgment. This is, of course, because the court cannot interfere with purely internal constitutional processes. Likewise, it is inconceivable that the court would now adopt interim measures interfering with the holding of a democratic referendum as requested by Guyana. Madam President, members of the court, I now come to the question of the court's lack of prima facie jurisdiction to hear Guyana's request. There is no dispute, to borrow the court's language in the Nicaragua case, that the court, I quote, ought not to indicate provisional measures unless the provisions invoked by the applicant appear prima facie to afford a basis on which the jurisdiction of the court might be founded. End of quote. Making sure that the court has jurisdiction over its request should therefore have been a key consideration for Guyana. Yet, the request barely touched on this issue, with Guyana merely stating in one single paragraph its line of argument. In yesterday's hearing, Mr. Reichler was even more limited in his approach, barely stating that, I quote, "there is no doubt about the court's jurisdiction, let alone prima facie jurisdiction, following the judgment of 18 December 2020, confirmed by that of 6 April. End of quote. This approach is wrong for one compelling reason. The court's decision on its jurisdiction on the merits is distinct from its prima facie jurisdiction to deal with Guyana's present request, for the simple reason that the subject matter of the request for provisional measures is fundamentally different. The fact that the court declared that it has jurisdiction to hear an application on the merits does not necessarily mean that it has prima facie jurisdiction to hear any request for provisional measures on the sole basis that the applicant asserts that it relates to the pending case. Instead, it is imperative that the request for provisional measures remain within the confines of the court's jurisdiction. This is because, as the court put it in the past, I quote, "An incidental proceeding cannot be one which transforms the case into a different case." End of quote. Yet, this is exactly what Guyana is attempting to do here. The court's jurisprudence features several applications of this principle. One of the most salient being the case concerning the arbitral award of 31st July 1989 between Guinea-Bissau and Senegal. As the court well knows, this case concerned the existence, validity, and applicability of an arbitral award on the maritime boundary of the two parties. The applicant, Guinea-Bissau, sought provisional measures against Senegal for alleged, I quote, acts of sovereignty by Senegal which prejudge both the judgment on the merits to be given by the court and the maritime delimitation to be effected subsequently between the states. End of quote. The court declined to grant the requested measures since the dispute did not extend to the rights of the parties over the maritime areas in question. In its request, Guyana tried to preemptively dismiss this jurisprudence. Yet this precedent is not only fully applicable, but also one in which the court will find guiding elements to dismiss Guyana's request. In Guyana's view, the fact that the court ascertained its jurisdiction upon the validity of the arbitral award of 3 October 1899, as well as the definitive question of the land boundary, gives it carte blanche to decide on any and all matters related to Venezuela, even its domestic affairs. In support of a claim that its alleged rights are being prejudiced, Guyana explained that Venezuela is about to impose its, I quote, own settlement of the land boundary by annexing the territory in dispute and subject to the settlement by the court. End of quote. But Guyana both misreads the court's jurisprudence and the goals of Venezuela's referendum. The fact is that, similarly to Guinea-Bissau's request, Guyana is asking the court to extend its jurisdiction and address matters not foreseen in its application. The referendum is an internal domestic matter and is not meant in any way to result in the annexation of the disputed territory. As such, Venezuela's referendum and its domestic consequences are not and cannot be the subject of the proceedings before the court on the merits of the case, and the requested measures by Guyana can thus not be subsumed by the court's eventual judgment on the merits. The court should therefore reject Guyana's request for provisional measures, just as it did with Guinea-Bissau. The point is here that the court will not grant any kind of measures when a jurisdictional link is lacking between the requested measures and the dispute at hand. Venezuela insists on this point because it is fatal to Guyana's request for provisional measures. According to the 2020 judgment, the court has limited jurisdiction in this case to examine, I quote, the validity of the arbitral award of 3 October 1899 and the related question of the final settlement of the dispute relating to the land boundary between the Cooperative Republic of Guyana and the Bolivarian Republic of Venezuela. End of quote. In this respect, the referendum contested by Guyana cannot have any effect on the validity or invalidity of the arbitral award of 3 October 1899, or cannot have any effect on the related issue of the final settlement of the land boundary dispute. The referendum will consult the Venezuelan people on various issues. Venezuela's positions on these issues have been perfectly well known to Guyana for decades and are in fact constituent elements of the dispute at stake. If these positions did not exist, there would simply be no outstanding dispute. None of the outcomes of the referendum will have any adverse impact on Guyana's alleged title over the disputed territory, and even less create a risk of irreparable harm to Guyana. Guyana's request for provisional measures thus falls outside the scope of the dispute over which the International Court of Justice has upheld jurisdiction, meaning that the court lacks prima facie jurisdiction ratione materiae to deal with Guyana's request. From what precedes, it is evident that Guyana's request for provisional measures has multiple deficiencies, chiefly amongst which it deals upon matters which have been known by it and the court since a long time. Furthermore, it is clear that the court lacks prima facie jurisdiction over every single one of the requested measures. First, Guyana seeks an order so that, I quote, Venezuela shall not proceed with the consultative referendum planned for 3 December 2023 in its present form, end of quote. This is, as I explained, a glaring interference in another state domaine réservé and wholly unprecedented. To our knowledge, no court or international tribunal has ever prevented a state from conducting a referendum. Most importantly, the holding of Venezuela's referendum falls outside the scope of the dispute as defined by the court itself. Second, Guyana doubles down, stressing that, I quote, in particular, Venezuela shall not include the first, third, or fifth questions in the consultative referendum, end of quote. If provisional measures are not warranted to prevent a referendum from taking place, they are all the more unfit to unilaterally amend the scope and content of that referendum. The court's order would have the effect of giving a say to Guyana over what Venezuela is asking its citizens. If this is not a breach of the customary principles of non-interference in the internal affairs of states and sovereign equality of states, I do not know what it is. Third, Guyana triples down, seeking an order to ensure that Venezuela will never conduct any referendum that will include, I quote, any question encroaching upon the legal issues to be determined by the court in its judgment on the merits. End of quote. We are back here in the domain of the hypothetical, and of course very far away from the court's jurisdiction, 𝘔𝘂𝘵𝘗𝘵𝘯𝘵 over the case. To repeat, the planned referendum has no relation to the legal issues in dispute in this case and as defined by the court. Fourth, Guyana asked the court for an order so that, I quote, Venezuela shall not take any actions that are intended to prepare or allow the exercise of sovereignty or de facto control over any territory that was awarded to British Guyana in the 1899 Arbitral Award. End of quote. As explained at the outset, Guyana has a history of crying wolf over Venezuela's alleged intentions with respect to the disputed territory. The court, however, has no jurisdiction to grant measures addressing a hypothetical intent to take hypothetical measures that would hypothetically be in breach of Guyana's rights that are in any event not plausible. Finally, Guyana seeks a non-aggravation order. This request must be rejected since, as the court made clear, I quote, such measures can only be indicated as an addition to specific measures to protect rights of the parties. End of quote. Since the conditions to indicate the specific provisional measures requested by Guyana are not met, the court, I quote again, cannot indicate measures solely with respect to the non-aggravation of the dispute. In any event, Guyana's unprecedented and unjustified request that such measure be imposed on Venezuela only must be rejected. Not only would it be contrary to the court's jurisprudence constante, it would also be legally inappropriate in light of Guyana's wrongful actions as described by the Vice President of Venezuela. Therefore, the court should dismiss in toto Guyana's request for provisional measures, as such measures infringe upon Venezuela's domaine réservé, and the court lacks prima facie jurisdiction over the measures. Madam President, distinguished members of the court, this concludes my presentation. I thank you for your attention and kindly ask you to give the floor to the agent of Venezuela, His Excellency Ambassador Samuel Moncada, for his concluding remarks and the final submissions of Venezuela.
I thank Professor Mbengue for his statement, and I now invite the agent of Venezuela, His Excellency Mr. Samuel Moncada, to take the floor. You have the floor, Excellency.
Madam President, respected members of the court, ladies and gentlemen, the dispute over the Guayana Esequiba is the story of a Venezuelan territory illegally occupied by the colonial power, the United Kingdom, under the threat of the use of force, and which, together with the United States, committed fraud in the negotiation of the 1897 Treaty of Washington and in the arbitration that allowed the territorial theft from Venezuela. In a nutshell, the dispute over the Guayana Esequiba is the story of a crime from which the Cooperative Republic of Guyana benefited. The Paris fraud of 1899 was so serious that the United Kingdom agreed to sign a treaty to correct the injustice committed by the empires. In 1966, the United Kingdom of Great Britain, British Guyana, and my country agreed to seek a satisfactory and mutually acceptable solution for the practical settlement of this controversy. Today, the Cooperative Republic of Guyana is bound by this provision and shall honor them. Madam President, respected members of the Court, in international law, there is no restriction on the conduct, terms, or scope of a referendum on issues relating to matters essential to the life of a nation. In the case of Venezuela's territorial integrity over the Guayana Esequiba, there is no provision in the Geneva Agreement of 1966 that prevents the Bolivarian Republic of Venezuela from holding a referendum on its territorial rights. The provisional measures requested by the Cooperative Republic of Guyana in order to prevent Venezuela from carrying out a popular referendum on its rights over the Guayana Esequiba are in violation of international law. In addition, such a request constitutes an attempt to abuse the court for the purpose of intervening in the internal affairs of a signatory and founding state of the Charter of the United Nations, such as Venezuela. I wonder, is Guyana neglecting the tenets of sovereignty and self-determination enshrined in the Charter? On the one hand, an attempt is being made to hide the historical truth about the territorial dispossession and the null Paris Award of 1899. But at the same time, an attempt is also being made to silence the voice of the Venezuelan people, who have endured for 2 centuries the occupation, aggression, and judicial colonialism regarding the Guayana Esequiba. In short, Guyana's actions seek to silence the memory of a people who, generation after generation, have not forgotten the extent of their national geography and who will never renounce the rights of sovereignty and territorial integrity. These are the reasons why we have called for a referendum in Venezuela. These are the reasons why, on the 3rd of December 2023, all Venezuelans will go to the polls. Madam President, respected members of the Court, in conclusion, I present to you the final submission of the Bolivarian Republic of Venezuela. In accordance with Article 60 of the Rule of Court, and having regard to the request for the indication of provisional measures of the Cooperative Republic of Guyana in its oral pleadings, the Bolivarian Republic of Venezuela respectfully submits that, for the reasons explained during these hearings, the Bolivarian Republic of Venezuela asked the Court to reject the request for provisional measures filed by the Cooperative Republic of Guyana. Finally, may I be permitted to convey, on behalf of the government and the Venezuelan people, our deepest gratitude to you, Madam President, and to the members of the Court for your kind attention. We are very grateful as well to all concerned, to the Registrar and his staff. We, likewise, extend our gratitude to the interpreters, who have done an excellent job. In particular, we appreciate that this oral proceeding has been interpreted into Spanish. Our thanks go especially to Guyana's distinguished agent and to the ladies and gentlemen making up its delegation. And last, but certainly not least, I would like to express my heartfelt gratitude to our delegation, including our brilliant legal team. Madam President, respected members of the Court, this concludes my statement.
I thank the agent of Venezuela, whose statement brings to an end the single round of oral argument of the Bolivarian Republic of Venezuela. as well as the present series of sittings. In accordance with the usual practice, I shall request both agents to remain at the Court's disposal to provide any additional information the Court may require. The Court will render its order on the request for the indication of provisional measures submitted by Guyana as soon as possible. The agents of the parties will be advised in due course as to the date on which the Court will deliver its order in a public sitting. Since the Court has no other business before it today, the sitting is declared closed.